Assalamu alaikum wa rahmatullahi wa barakatuh. Welcome back, viewers, to another episode of Pathways to Prosperity with me, Ameen Hassen, where we discuss all things finance. Today, we carry on from one of our previous episodes where we were discussing the importance of having a will and the importance of a Shari'ah will in the context of South Africa. And what we thought we'd do is share with you some of the key fundamentals that you need to keep in mind when drawing up a will in South Africa, taking into account Sharia law as well as South African law. So we're going to have a very basic discussion, give you some key points and some takeaways for you to go and think about, and hopefully it'll help you on your journey of having a congruent fiduciary plan in place. So let's start off. What is a will? A will is a document in which a person sets out what they want to happen to their estate when they die. Anyone over the age of 16 in terms of South African law is deemed to be competent to draw up a will and determine how they want their effects to be distributed. A will, very importantly, must be in writing. The will must be dated. You must revoke in your will all previous wills. Why is this important? Because let's take a scenario. If I drew up a will on the 1st of January 2024, and I drew up another will on the 1st of July 2024, and both are presented to the master, but one is signed and one is unsigned, the master will hold up the most recent valid signed will. If in your will you say that you don't revoke your previous will, they will not revoke the previous will and they will uphold that document as a valid living document. This is very important. Your signature as the testator for males or the testatrix for females must appear in full on every page. And these things that we're giving you are very important. You'll see a court judgment that we'll share with you in a little while on why these things become increasingly more important. Your will must have 2 witnesses. The witnesses must be above the age of 14, and they must sign in full on the last page and preferably initial each page. Importantly, witnesses cannot be beneficiaries of your will. Sometimes when we're drawing up the will, we call our sons and daughters, or we call our spouse, or we call a family member and say, please witness my will. The master will nullify their benefit because they are witness to the will. So they will be disqualified in receiving anything from your estate if they are a witness to your will. You must choose an executor. We'll explain what the executor is. And the executor may not be a witness, but may be a beneficiary. So if the executor is an heir, that's okay. But remember, witness cannot be a beneficiary. Then some of the things you need to think about when you draw up your will. What do you want to happen to the benefit of a minor child? Do you want this to go into a testamentary trust? Do you want to create an inter vivos trust, a trust now while you are alive? Or do you want the trust to be formed upon your death? Because if you don't make accommodation for this, the benefit to a minor child will vest into what is known as the guardian's fund. And the guardian's fund would then take care of the benefit of a minor child. So this is a very important consideration. Obviously, this is in the scenario where both parents die or adequate guardian cannot be found. Think about guardianship of your child. Remember, the Sharia has very specific rules when it comes to guardianship. And in law, you have something that's called a warden and a guardian. Now, this is very different. Who the child's ward may be is something different to who the child's Sharia guardian is. And this is important consideration when you're drawing up a will if you have minor children. The original will must be kept safe. In terms of law, a copy of the will is not deemed a valid will. This is very important. So you need to keep that original will in a safe place or with a fiduciary services firm Pay the safekeeping fee, but at least you know that your will be upheld. Ensure that you have taken into account all of your assets. If you've given assets in your lifetime, you don't want it to form part of the Sharia calculation, ensure that you record that. Sometimes we forget about an asset. We take for granted the small little ring that we inherited from our grandmother in the cupboard. Or we take for granted the clothes in our closet. Sometimes, in our lifestyles that we lead, our clothes actually run into quite valuable sums of money. So take all of your assets into account. Maybe you got a specific coat that's made from mink and you want it to go to one of your daughters. Give it to your daughter in your lifetime, or specify that in your will, because it is something of real value. Importantly, you need to also remember what your matrimonial regime is. So remember, if you are married in community of property or ANC including the accrual, your will only deal with your portion of your matrimonial property regime. So let's say I'm married in community of property and I have a R1,000,000 estate. The first thing the master will do will give 500,000 Rand to my spouse because of the matrimonial regime. And then my will only deal with the remaining 500,000. So this is very important when you are drawing up a will, if you are married in community of property or ANC including the accrual. So the matrimonial property regime becomes important. And remember, we touched on this with Mufti Umair earlier on in our series. If you die without a will in South Africa, your estate will be wound up in terms of the law of interstate succession. So the master comes in and decides what must happen to your estate because you don't have a will. And the last one before we move on to the next section is your will must be valid, or it must meet the requirements of the provisions of the Wills Act in South Africa. And this is why we are articulating these points to you, because these are the key items in order for you to have a valid will in terms of the Wills Act. Now, a big question that we get asked all the time is, what is the executor? What are some of the explanations that we could provide to you in terms of what an executor is? So it's important for us to have an executor because the winding up of the estate is quite a complex affair. So you would need somebody that understands these laws, understands the processes, understands how the calculations work in order for your estate to be wound up correctly. The person, this is important, sometimes you have institutions or people that are drafting your will that impose upon you that they must be the executor of the will. So this is very, very, very important. In terms of law, the person drafting your will does not need to be the executor of the will. They can be, but it's not a must. You can appoint more than one executor. In some instances, it's good to have a family member as the executor and maybe a fiduciary services firm. So think about how many executors you want, the profile of those executors. Remember, the executor is there to oversee and advise on the winding up of your estate. Generally, executive fees are 3.5% plus VAT. This is the regulatory maximum. So you can agree with your executor up front anything between 0 and the regulatory maximum of 3.5% plus VAT. Importantly, we'll get to this in a little while, this fee is deducted from your estate before anything else. So when you're calculating the liquidity of your estate, this fee needs to be kept in mind. And maybe consider a corporate or institutional executor. Sometimes we appoint an executor out of love or affection or kinship. So I may say, hypothetically speaking, I want my brother or my father to be the executor of my estate. But in all probability, my father may predecease me. My brother may predecease me. And in that instance, you then have to go and update your will and change the executor. So sometimes think about having an executor as a corporate institution or fiduciary services firm that may outlive a natural person. Now we get into the Islamic will, and these are some very important considerations when you're drawing up your Islamic will and putting your plan in place. The format of your Islamic estate being wound up is as follows. The first thing that will be deducted from your estate will be all of your debt obligations. So personal obligations will include, personal debt obligations will be debt, so debt contracts. either with a financial institution or personal debt contracts. Often we find at our janazah salah, many of the men would have witnessed this. The imam or the senior of the family member would stand over the janazah and say to the public, if there's any debts outstanding, please come through and collect it from the family. So the first thing is Allah subhanahu wa ta'ala fulfills what we know as huququl ibad, the rights of human beings. So your personal debt obligations will be covered first. It will also include if you have any outstanding dawah, mahar, if you have any funeral expenses, this will be covered. The administration of the estate. So your estate duty tax and your executive fees will come out first, because these are contractual obligations or tax obligations in the country that we live. So because these are deemed as debts in Islam, these are to be honored first. And this is a very important thing, because if, hypothetically speaking, you have R1 million estate, but your personal debts are R1 million, you're already in 250,000 Rand deficit in your estate because of the 20% estate duty tax and the executive fees. So when you're doing and that means your heirs actually get nothing. Even though you have R1 million estate, because you have R1 million in debt and your executive fees and estate duty fees, your heirs actually get nothing. So when we're calculating what you're actually leaving behind, it's important to take these things into account. Once these are dealt with in the estate, the next thing that is dealt with is what we call huququllah, the rights of Allah subhanahu wa ta'ala, or your religious obligations. Your outstanding zakah, your outstanding salah, if you haven't performed hajj, outstanding kafara, all of these items would then be deducted after your personal debts are deducted. Importantly, this cannot exceed 1/3 of the world. So Allah subhanahu wa ta'ala has put forward a limit on His rights. Look at His mercy. He says in terms of huququl ibad, there's no limit. You ensure that you fulfill the rights of humans in its full. But in terms of my right, Allah subhanahu wa ta'ala caps it at 1/3. Then you have the freedom of testation up to 1/3 of your estate. So you want to give money to a charitable fund, you want to give money to a non-heir, you can do this up to a maximum of 1/3. Now, important calculation is your religious obligations plus the freedom of testation element combined cannot exceed 1/3. So if both of these items are reaching more than 1/3 in total, or added up together, the Islamic jurist that is helping the estate manager or the executor calculate these things will abate these two items in accordance with the Shari'ah. So the Shari'ah has a formula, and these items will abate depending on whether you follow Imam Shafi'i or Imam Abu Hanifa rahimahullah. Then the Islamic jurist will then calculate it based on the principles of the Shafi'i madhab or the Hanafi madhab or Maliki or Hanbali. Once these items are dealt with, once your personal debts are dealt with, your religious debts and any bequests in terms of the 1/3 freedom of testation, the residual of your estate would then be calculated in terms of the Islamic law of inheritance and the formula that we discussed previously. And I want to close with some important comments. There was a case in 2012 in the Supreme Court, and the case was Robenheiner versus Robenheimer. And I want to read out some of the concluding remarks in the judgment from the Supreme Court judge. And the reason why I'm doing this is to emphasize how important it is to ensure that we have a valid will and ensure that we have a good, sound financial advisor advising us on how to do these things. So these are the actual words of the Supreme Court judge. He says, "It is a never-ending source of amazement that so many people rely on untrained advisors when preparing their wills, one of the most important documents they are ever likely to sign. A high court decried the number of instances in which wills had to be rejected as invalid due to a lack of compliance with prescribed formalities." So, and then it carries on, and the court advises at the end, to consult only persons who are suitably trained in the drafting and execution of wills and other deeds containing testamentary dispositions. The reason for this is we have no idea how many times wills are actually invalidated by the master's office. And oftentimes in society we say, oh, it's taking so long to wind up the estate and the master of the court is taking so long. Many times this isn't a fault of the master. It's actually a fault because the will is invalidated or matters of the estate are not wound up correctly. There isn't sufficient liquidity in the estate to pay the estate duty taxes. So all of these things are important so that when you die, your heirs are not prejudiced, your estate can be wound up quickly, all of the liquidity required is available, and your beneficiaries can get their funds as quickly as possible. So we urge you to please consult a proper financial advisor. At Standard Bank, we've got a full fiduciary services team that can help you with your will, your inter vivos trust, or your testamentary trust, executive services, and also in ensuring Sharia compliance across the board, because this is a wajib act in terms of the Sharia. And we will ensure that these two things are merged. The liquidity calculations of your estate, ensuring that there will be sufficient liquidity when you die to meet your personal obligations, religious obligations, taxes, executive fees, etc. And to ensure the proper structuring of your will, to ensure that you're meeting not only the requirements of the Wills Act in South Africa, but also fulfilling all of the requirements of the Sharia. So please, viewers, take this as an important consideration. Call out to us if you need help, or a sound financial advisor that has the expertise in this. So inshallah, you die with peace of mind, knowing that your beneficiaries are protected. And we make dua to Allah subhanahu wa ta'ala that He gives us a good death so that He may be pleased with us, inshallah. Until next time, Assalamu alaikum wa rahmatullah.